All right, let's jump right into this explainer and demystify exactly what the May 2026 USCIS Policy Memorandum actually means for your adjustment of status application. If you, or maybe someone you know, is currently navigating the U.S. immigration system, you've probably heard all the buzz around Memo PM 602019. Now, I know it sounds like a bunch of bureaucratic jargon, but it represents a truly monumental shift in how the government evaluates applications for permanent residency. So we're going to bypass all that jargon today and unpack the facts straight from the source material. By the end of this, you'll understand exactly what the new expectations are, how the criteria have fundamentally changed, and most importantly, how you can adapt. To help lower your anxiety and keep things perfectly clear, here is our roadmap for today's explainer. First, the 2026 policy shift. Second, the discretionary framework. Third, building a strong application. Fourth, the filing process. Fifth, after you file. And finally, number 6, practical tips for success.
Starting right at the top with Section 1, the 2026 policy shift.
Now, the exact phrasing used in the government's memo is honestly fascinating. Adjustment of status is now explicitly treated as an, quote, extraordinary discretionary form of relief, or administrative grace. It is no longer just some routine benefit that gets rubber stamped because you check the right boxes. While this memo absolutely doesn't change the underlying statutory eligibility rules or stop you from filing your Form I-485, it radically shifts the lens through which immigration officers view your case. They are now officially directed to heavily scrutinize every single application.
But hey, before we even get to the new discretion rules, you still have to prove your fundamental eligibility under INA Section 245. This magic number is basically the bedrock of your entire application. You have to verify that you're physically present in the United States, that you have an approved immigrant petition or can file concurrently, and that an immigrant visa number is immediately available to you. You also can't be subject to specific bars to adjustment, things like unauthorized employment or unlawful presence, unless, of course, you qualify for an exception. Basically, statutory eligibility is your entry ticket. Without it, discretion doesn't even come into play.
Moving forward, you have to completely shift your mindset. The old way? Well, it was kind of like a trip to the DMV. You'd fill out a routine form packet, attach a few documents, and wait for that stamp of approval. But the new, post-memo reality means you have to view your application as a persuasive legal argument. A bare-bones application is now incredibly risky because the burden is entirely on you. You literally have to prove to the adjudicator why you deserve this administrative grace.
Let's move right along to Section 2, the discretionary framework.
So, what is the central hinge upon which your entire application will now be judged? It's a concept called the totality of the circumstances. Under PM 602-0199, adjudicators aren't just looking at 1 or 2 checkboxes anymore. They are looking at your entire life history. They have to weigh all the positive factors against any negative factors and ultimately decide, is granting your adjustment of status actually in the best interest of the United States?
I want you to imagine the immigration officers using literal scales of justice to weigh your life. On one side, you have the negative factors the memo emphasizes, things like failing to depart after a temporary stay, violating the terms of your status, any sort of fraud or a criminal history. Even conduct that's just inconsistent with your non-immigrant intent gets scrutinized now. On the other side of the scale are your strong positive factors. We're talking deep family ties in the U.S., like a citizen spouse or kids, big community contributions, a flawless tax record, and a long period of lawful residence. You have to affirmatively prove the positive side so heavily that it completely, undeniably outweighs anything negative. Now that we know the stakes, let's look at Section 3, building a strong application. You still absolutely need to gather your core non-negotiable documents to establish that baseline eligibility we talked about. This includes the latest edition of Form I-485, your Form I-693 medical exam, which in most cases must now be submitted with the initial filing, a copy of your approved petition, passport photos, the proper filing fee, and undeniable proof of lawful entry like your I-94. If you miss these, boom, your application gets rejected before the officer even has a chance to weigh your discretionary factors. But here is how you actually tip those scales. You must affirmatively provide this discretionary evidence. I can't stress this enough. This is where cases are won or lost under the 2026 memo. You need a detailed, sworn, personal statement explaining your history and exactly why a denial would cause hardship. You need glowing character letters from community leaders, teachers, or pastors. Bring in your IRS tax transcripts, deep family evidence showing bona fide relationships, and a meticulous record of your complete immigration history.
You are painting a vivid picture of a person who is highly integrated into society and possesses unquestionable good moral character. And when it's time to package the whole shebang together, whatever you do, please don't just throw a giant stack of paper into an envelope. Tie all your evidence together with a meticulously drafted cover letter. Think of this letter as the ultimate roadmap for the immigration officer. It needs to explicitly address both the positive and negative equities in your case, directly applying that totality of the circumstances standard we discussed, and firmly requesting favorable discretion based on the hard evidence you provided.
Which brings us to Section 4, the filing process. By breaking it down into these 3 completely manageable steps, you can keep the anxiety of this whole bureaucratic process under control. Step 1, gather your evidence. Step 2, double-check your forms for complete accuracy. Step 3, track the delivery to the correct USCIS lockbox. Always remember to check the current USCIS website for direct filing addresses. Oh, and if you want work or travel authorization while your case is pending, this is exactly the time to include Forms I-765 for employment authorization and I-131 for advanced parole. And it goes without saying, keep copies of literally everything you send.
Once that package is out of your hands, here's Section 5, after you file. Just a heads up, processing times can easily stretch way past 12 months. Around month 1, you'll likely have a routine biometrics appointment. But here is where the new policy really shows its teeth. Around month 4 or later, you need to be highly prepared for a request for evidence, or RFE, specifically targeting your discretionary factors. Further down the line, many cases, especially marriage-based ones, will require an in-person interview. You must walk into that interview completely ready to eloquently discuss your positive equities. Ultimately, officers must explain any discretionary denial in writing, proving that they actually balance the factors.
Let's wrap this up with Section 6, practical tips for success.
Because the stakes are so incredibly high right now and the outcomes are so heavily fact-specific, hiring a reputable immigration attorney is absolutely a game changer to help you anticipate those RFEs. Furthermore, meticulously maintain your current lawful status. You want to avoid any gaps or violations while your case is pending. And whatever you do, don't withdraw your application prematurely just out of panic. Pending cases do continue. Now, for some applicants, consular processing might actually be a safer alternative if the risk of a discretionary denial is just too high. Bottom line, document everything, assume officers will heavily scrutinize your intent, and always stay updated on the official USCIS policy manual.
As you prepare your application under these heightened standards, I want you to look at this final question and ask yourself honestly, have you truly built the evidence to prove your case serves the national interest? The days of simply checking the boxes are gone for sure. Earning this extraordinary administrative grace takes deep strategy, meticulous preparation, and an undeniable presentation of your positive contributions to society. Does your life story leave the adjudicator with absolutely no doubt?